everyone, and welcome to another episode of The Exchange. I'm Tom Lenfestey, founder CEO of the Law Practice Exchange, excited for episode 2. And today we have no better guest out there, truly no better guest out there to talk about, deal killers or what helps bring deals together in law firm sales. I'm proud to work with him, be a teammate for the last few years, and really call him our chief deal maker, although sometimes is our chief deal killer as well. Always looking out for what makes a win-win deal. So I'm happy to introduce Michael Di Gennaro. Michael is Chief Growth Officer and Head of Advisory Services with the Law Practice Exchange. Mike, welcome to the program.
Thanks, Tom. Thanks for having me here. Great. This is my second podcast, so just that caveat in case things go sideways from time to time, but happy to be here. I guess just you asked me to introduce myself to your audience, and so basically, yes, I've just stepped into the chief growth officer role here at the Law Practice Exchange, and I'll give you background in a bit as to why I just stepped into that. It's vis-a-vis where the Law Practice Exchange is as a business and what we've evolved to in my tenure here at the Law Practice Exchange over the last 3 years. But as far as background, I went to Cornell undergraduate, got a degree that was heavily economics based, and then went to the Federal Reserve System after I graduated. I practiced there as an assistant economist, doing lots of quantitative and programming type things. And after that, had a role at Young & Rubicam, which is a major global advertising agency, which I believe was subsumed into the British advertising company WPP. And there I did quantitative brand management, some more quant stuff, different field. And then finally prior to law school at least, was hired as a litigation consultant of all things for a company called ARPC. I worked a lot on asbestos claims for workers that had been exposed to it. Happy to do that. It was great. I had an intro to participating in depositions and such in various areas of the country. Got accepted to NYU School of Law, trucked on and made it through the program. Out of law school, headed off to the Federal Reserve System once again to practice bank regulatory law. And a lot of what I did there was regulating or overseeing the financial services regulations of bank mergers and acquisitions. One of the more well-known M&A deals that I worked on was TD Bank's acquisition of Commerce Bank to have a East Coast to create a East Coast financial services entity. But large banks weren't really my thing, and so I headed off and I took a job in the legal recruiting world. I was based out of the Charlotte office. And, that's where I met Tom. But interestingly enough, I don't know if you recall that deal that you were on, Tom, but yeah. A proper Southern gentleman leading that law firm. And we were happy to acquire his law firm and take him in. And I was charged with helping staff up that transaction there at the law firm. And Tom and I stayed in touch for several years. I was across the table from him on a number of deals. As a recruiter, I was really fascinated about true sale practice. It's something I never had seen before. All sorts of conventional mergers and reaffiliations and such, but I had never given much thought to true sale, and I found it very interesting. And I came to Tom asking for a job, and he saw fit to hire me in. And that's how I landed at LPE. And I've loved my time here and look forward to many great things.
Thanks, Mike. And, I think the biggest thing that you really share is service in the legal community in various ways, right? And then that branding, the marketing aspect, which really I think all of us on the team come together to try to share with attorneys as we help them through their planning, through their strategic goal setting, and beyond to really get to that finish line. So I appreciate that. And, Michael, correct. You sit today in this really, I call it chief deal maker, situation where really the inflows of, buyers and sellers, especially those private market deals, but of helping the lawyers on both sides or a lawyer investor, MSO, private equity, whatever it would be, navigate how to bring a deal together, right? That's kind of where you are.
I now work on are what we call our elite deals. So LPE selectively represents sellers. We handle currently anywhere between 10 to 12 deals at once. I'm just returned from the frozen north of New England on a deal that we have in motion currently. And so I do see all sorts of things on both the buy side and sell side, some successful, a lot that is not successful in getting a deal done. And yeah, I've learned a lot doing that.
And that's the point of today's episode, Mike. We're going to talk about deal killers and game changers. Truly try to just, for you and I to kind of talk through what we strategize of lessons that we've learned from some of these real law firm sales. Some that have, had bumps along the way, but still made it through to the finish line. Others that should have, right? Or maybe should not have, but overall that they didn't make it, right? Even when maybe the owner wanted to make it, and kind of really go through those of a sharing of stories that we've been through, so that hopefully it helps others prepare. Right? That's the real goal, is to help others be more prepared, whether you're looking for a sale or you're looking to buy. What are those things that seem to pop up a lot of times that potentially are those things that could derail, right? And so the first thing that I wanted to go at is, Mike, look at the deal that was supposed to close, right? So this illusion of certainty, right? Like it's really supposed to close, it's moving along, and then there's just surprise. Right? There's surprise of potentially that. Can you consider, like, is there a one, without, of course, naming names or anything else, like share a story with the listeners of a deal that really, was on track, should have, was checking all the boxes, but potentially didn't close, and why?
Sure. Yeah, I think one specifically comes to mind. We were working on a deal for a personal injury law firm seller in the Southeast. Great brand, great marketing. The firm had changed a lot for the better over time. Came to us for valuation. We analyzed it. We found some areas for improvement. The seller went back and they made those improvements, and then we went to market. When we went to market, the sole equity holder of the firm had family members present, but didn't quite realize that those family members were actually co-equal or maybe more significant decision makers in that deal. And we learned our lesson the hard way, that you need some serious buy-in, and we need to understand who the stakeholders are in any deal.
And Mike, family members we talk about, but like, who typically is that you're looking to really get on board? It's spouses, right? I mean, both spouses who a lot of times, we've seen this repeatedly. It's kind of a common aspect. Both are vested into the ownership. One may be a lawyer that actually owns the firm, but the other has been there supporting either emotionally or, working in the firm or, helping build in different ways for the last, 20, 30, 40 years, right? So both,
Certainly.
One may be the owner, but both feel ownership. Would that be right?
Yes, that would be right. What I would say is it's not so obvious on its face the way law firms are traditionally set up, because again, as you said, Tom, that individual, that spouse, is a non-lawyer. And so while they may have a decision as far as how the firm is administrated and operated, they're not an equity holder. My observation now with the current legal scape is that if that family had set up their firm structure under what is the current MSO, LSO environment, which some families are doing, such that sons and daughters don't have to go to law school, don't have to become lawyers, then, perhaps that non-owner of the law firm, that non-owner family member would be an owner. They'd be an owner of the MSO. And you'd know right up front that if they were transacting, that they are an equity holder, they are a stakeholder. But it's not very clear in the way law firms are treated who the stakeholders are, how much influence they have. And part of this is face, I would say. It's like the equity holder may want to have this image or this bravado of being in charge. That's part of the persona.
Well, and I think the interesting part, Mike, we can probably share some other scenarios too, that it's not just spouse. But, one of the things that, over the years we've kind of encountered is a lot of times you have law firm owners contacting us and saying, hey, I need help finding an exit plan or a succession plan or selling my firm. And the reasoning behind it is because their spouse that is at home who's retired is like, look, you're working too much, right? So in one sense, we sometimes have that, significant other at home motivating for the sale. And in others, right? They're have their own emotional, probably, attachment to ownership and are worried about the spouse who was running the firm. Like, what are they going to do? They work 6 or 7 days a week. They love, doing this. Like, so there's always this back and forth. And I think, we've talked in the past about the emotions of it, right? Like, truly the emotions of that piece. What would you recommend if I'm a law firm owner sitting here and I have a significant other that's invested either years in supporting me or, supporting, in the firm to help build it or anything else? What is the best way, do you think, to like really sit down and get both on the same page, from the start, right? Because I think that's really it. Like one may have a different view of the end goal than the other. Like, have you seen certain things work or what would you recommend?
Well, what I would recommend, as I said on the last podcast that I did, is therapy. Honestly, therapy. This is a major life decision that's being made. We know all the classic ones: marriage, divorce, death in the family, things that really trigger emotion, obvious emotional triggers. But this transformation of your life is another trigger, and albeit this isn't these owners have invested in a business that oftentimes has their name tethered to it, that their clients know them personally. Some of their clients have been friends of theirs their whole life. And this is going to be a much more tumultuous change than if you were selling your HVAC business or the nail salon or any entity that's more of a pure money generating, cash flowing business. But you're not so tied up personally in generating that revenue. You're operating like a pure business operator. So that's something as you know, Tom, you and I have been trying to find or and have successfully brought an individual into our trusted partners. Sort of talking that through. Before you're really ready to go to market, talk through what that looks like. Talk through what those changes are and really come to terms with them beforehand, because it is a big decision. I think one of the red flags that I saw in that last deal, and I remember this on the very first call with a buyer. I remember I was sitting in a coffee shop, and the buyer is someone I really like, very competent, and the wife of this owner mentioned, we're just exploring. It's like, I'm like, no you're not, I didn't say that, but like tons of red flags went through my head. And at the end of that call, I really thought, maybe we should rescind our representation here until the couple, the husband and wife, really got on the same page about what was going on. The husband was very motivated to sell, but that raising that red flag of this is an exploratory exercise, not the best foot to put forward in a deal.
Well, I think, Mike, too, we talk a lot about the emotions, right? If you're a law firm founder, owner, right? And then you're looking to do this, sometimes that founder is making that decision to move forward. Sometimes they're reluctant, but the significant other has those emotions, right? The family members do have those emotions too. And it's fear for their loved ones, right? Like in that situation, right? The significant other was fearful of like, what is my spouse going to, like, they're going to regret selling this, I believe, right? And so they were putting up emotional blocks along the way, like what they shared with you of like, we're just exploring. When, the founder's like, no, we're not, we're going, right? But to get everybody, I think, where you use therapy, and we have some ex-lawyers in our network, if anybody ever wants to talk to them, that really are kind of filling this void of helping lawyers transition into retirement mindset, exit mindset, right? And how that can be done. And I actually think it's a great thing. Like a mutual friend of ours, Camille Stell, had always kind of used this instruction to a lot of the law firm owners. Before you say like, I want to really be done and what I'm going to do, take a week and go home. And just stay home, take a staycation and spend that week with your significant other and see if they want you home for the week. Any other examples that you want to share?
As far as buyers or sellers, I have some interesting buyer examples of how to kill a deal. I think with the recent entrance of private equity to the marketplace, Tom, you and I are on a lot of those calls with those buyers. We're forming those relationships. We form those relationships, but a lot of these private equity buyers come at this process in the law firm acquisition space with an attitude that they've had throughout their tenure in PE, attitude that has worked for them in successfully transacting in other industries. That attitude really just doesn't fly with a lot of our law firm clients. I would say we had an interesting deal with a client of ours that's on a sell side client of ours that's very profitable, has created something, a true business in a legal space where they're trendsetters, they're path breakers in terms of what they did. And I can never get out of my head a disastrous experience I had with a member of a family office, and this seller had worked and devoted a lot of time and thought and invested in engineers to create really superior processes, systems, and procedures, which, as you know, are integral to really getting good value for your law firm, and hadn't done his homework and was first came in touting all of his intellectual superiority to everyone on the call to let everybody know where the pecking order supposedly was. And then, after doing that, being dismissive of the processes, systems, and procedures that, law firm founder clients had worked so hard at developing. And that was essentially the secret sauce behind why they're so profitable, why they're so lucrative. Well, needless to say, our client isn't working with them. We're not working with that client anymore.
Right.
Check the attitude at the door, right? That would be one of my pieces of advice.
Yeah, I think that's a key part. It's a great point. It's the deal killers don't always come from the seller side, right? They come from the buyer side as well. And having that right buyer strategy, knowing how to speak lawyer, right, is a key part. I mean, I think as lawyers, we would always say, oh, we're not so different than everybody else. Like, we're not wired a certain way. We talk a little bit different. We have our thought process be a little bit like, tell me what step 27 is and how it's going to be successful before I take step one. And, we have this, like, we want to feel legacy. We want to feel fit if we're going through this. So yeah, that PE killed their deal really quickly, right, in that situation. Mike, moving on from like emotions and just how you present yourself or anything else, let's talk about operational deal killers. What have you seen in a deal from an operational side of the firm that really it's just going to kill the deal either at the beginning or throughout the process?
Yeah, I mean, I think it's your ability to understand your own law firm, and nothing helps you understand your own law firm by one, having a valuation done by experts that specialize in valuing law firm businesses, which are valued very, very differently than other businesses are, simply because a lot of the value of a law firm is in its goodwill and client base and name recognition and such. A lot of clients are tied to founders. So valuing that is a process that not only requires accounting but understanding of deal structuring, because that's integral in actually transferring goodwill to achieve that valued price. But to facilitate the process beyond that, you actually have to have systems, processes, and procedures in place where you can pull this data, and not just pull it but synthesize it. Ideally, you want to be able to touch a button and be able to measure performance throughout the firm, the performance of your staff, the performance of your attorneys, the performance of your case portfolio in the instance of a personal injury law firm per se. And a lot of law firms just aren't there. And it's understandable why. It's because lawyers go to law school to practice law. And being operating a business is a very different thing than practicing law.
Mike, would you say that if you know your data, you're a law firm owner and you know your data, like you can press a button and be like, here's my marketing channels, here's my intake, right? Here's where all my cases or clients come from. Here's my, profitability per attorney and everything else. You've got that. You've invested in that through software, through financial accounting, whatever else. Is that one of the biggest things that would really give buyers confidence?
Absolutely. I think when you know your own firm and you can get ahead of questions, so for instance, if you're in a meeting with one of these sophisticated types of buyers and they're asking you these sophisticated questions in these meetings, your ability to respond to that on the fly without having to go through formal additional information requests and carefully crafting responses or actually doing this research because you don't know that information right from the get-go. I think that's a big signal to a buyer. When you have that ability to do that, it's a big signal that the numbers that you presented them at the onset are real.
I think, so much of what we've done over the years is help lawyers understand the value, which you brought up, of their firm. But beyond that, it's really like what goes in operationally from the data and the financial to, really churn out the revenues and to churn out the profit and everything from that. And where I think not knowing that is going to, we've seen it repeatedly, going to really put a lot of fear in buyers. Where do all your, give us your where your clients come from. I don't know. They just kind of keep coming, right? Where do your marketing dollars get spent? I don't know. We have a plan. I think you can pull that from QuickBooks, right? Anything else. It shows a lack of really that business that is transferable, right? It's more about like you doing things you've done well, anything else from that side. And I think, Mike, the biggest thing, I mean, we probably can give a couple examples, different deals, but those are the things that sometimes pop up later because buyers like to do deeper due diligence, right? They want to ask more questions. And sometimes, even when you've gone through the valuation process, now it's going a little bit deeper. Like, my big recommendation is if you're a plaintiff attorney and you don't keep active case inventory, like values, from your portfolio, your team, anything else, if you don't know, that's a huge, huge issue to go and selling. So if you're looking at selling now or in 5 years, like my recommendation as a plaintiff attorney, a PI attorney, SSDI, workers' comp, like go through yours and keep it on an active basis. So you can push play, have all the details, and know what that's worth. That's just a great strategic asset to you, right? Mike, any other data points that you would say this is key for them to know or to track or anything else?
Yeah, well, I mean, some of it is in accounting, right? And the accounting methodologies that some of these firms use. It's like, as you know, recently we've been talking to quality of earnings experts because quality of earnings analysis of financials is something that a lot of personal injury law firm buyers are going to request, especially those that are private capital personal injury law firm buyers are going to request. And so you mentioned taking things a step further, going deeper. Yeah, maybe that's it. I mean, the buyer is going to perform their own quality of earnings. Why not perform yours in advance? Anything you can, arming yourself with that knowledge and being able to, give answers on the fly rather than having to take lots of time in an additional information request. Well, it allows you to push back. The buyer might be trying to beat you up in terms of price and what they're willing to pay and making a deal seem more risky than what it is. Being armed in advance of that and this quality of earnings analysis, at least with some of the larger law firms that we have, is just another tool in that kit where you're like, yeah, you're saying this? Well, how about this? I have this. This was created for me in advance. Wow, you're sharp.
And I think so much of it is like that cleanup to, especially maybe some smaller practices. There's larger practices that need a lot of, systemized cleanup on data and financial and accounting and, marketing intake. But overall on the small ones, they're like, it's just too much for me, right? Or I have historically have not done that. I remember years ago, Mike, I had one that was, a small little family law practice. And really the buyer's like, the seller's not providing the level of detail that we need or anything else. Like they just supply this. Well, it's because they never tracked the detail, right? I mean, they didn't track it. They looked at how much money each month was in the bank account. They knew the amount that they had to, pay their monthly expenses, and they took the excess. That was their whole system, right? Like go out, do this, create money, take the excess. And there's a lot of, I think, small firms out there that probably do the same. But if you're looking for exit, it doesn't have to be that you're now going back 20 years, right? It's really not like this huge task or anything else. Like my recommendation is if you haven't tracked like marketing intake numbers ever, just start doing it now, right? 3 months of a record of where clients come from is better than no like record of where the clients come from. 1 year of clean financials is better than none. But any examples or stories you can share about where that valuation gap on like, hey, my firm should be worth this, or somebody else, maybe again, it's a spouse or it's an advisor jumping in to say the firm should be worth this. Or sometimes I think the deal terms should be way more favorable than maybe what market would allow. Any examples of that you've seen?
Yeah, we see that all the time. Honestly, I think we've looked at, we've had our electronic exchange, the marketplace, for some time now, and where we see a lot of the deals killed is simply because of having, inappropriate valuation expectations from the seller. And well, why do they have those expectations? Well, they have a CPA that has never wrapped their head around a law firm transaction or ever valued a law firm business whatsoever. And so, it's a service industry business. A service industry business, well, great. Is it a nail salon? Is it a laundromat? What goes into, like, is every service industry business the same? Some will tell you, yeah, it is, but it's not. You and I both know that it's not. Again, going back to what I said at the beginning, the goodwill, the client base, you're transferring something different. And there's risk in that there's risk in that transfer that is not present in a lot of other industries. The founder of the law firm is probably going to have to be tethered to the buyer for several years after the transaction is done. And so no, you're not getting those multiples. The other is reading supposed authorities in terms of like, well, this is a bright line rule for what all the law firm should get. I think there was one estimate is 3.5 times earnings. Well, that you and I both know that that's not the case. So, you have this
For
book
some
that's widely
firms,
available.
yeah, there's firms out there for sure, but then there's some firms that are not. You and I've talked about that as, I think the most interesting part on us for the valuation gaps are where valuations come from different sources, CPAs, otherwise, they're just trying to apply information they have. But a part of it is like, hey, we can be proud of this. We've been doing this for almost 15 years. We've got almost 500 comp transactions and everything else to compare to, not just a law firm to a law firm, but a personal injury firm in the Southeast of this size to another personal injury firm in the Southeast of this size with this type of brand and this type of system. And that's really where they become unique businesses, right? And just trying to, I think for you and I, we're always trying to bring like why we're doing this podcast, education that just because a book somewhere says 3.5 times multiple for a law firm doesn't mean your firm's a 3.5. I think that's, an interesting part. Mike, I want to shift gears a little bit because there's always this valuation gap sometimes naturally between a buyer and seller. But I want to shift from like not just deal killers. Like I don't understand the valuation or my advisors don't. But what are some creative deal structures? Let's say I'm a buyer and I say this firm's worth, $2 million, right? You're a seller. You say this firm is worth 3 or more, right? From that side. What are some deal savers, right? What are some like creative strategies that you've used to really close this valuation gap, even when maybe it's not a lack of knowledge? It's just that aspect of I'm a seller, I believe this and I believe I'm right. I'm a buyer, I believe this, and there's risk to, my investment acquisition. And anything you want to share on kind of strategies that have saved deals in those situations?
Yeah, sure. So as you know, like making performance or payment contingent upon performance is a good way of being able to apportion risk appropriately between buyer and seller. And a lot of what these deals are is risk apportionment. The buyer wants to make sure the deal cash flows for them. There's not going to be hidden bumps that they never uncovered in diligence, etc. And the seller has this very specific knowledge about their firm. They've known what they've done in the past and what there's a potential to do. And it's like, okay, put your money where your mouth is. Let's make a bet on who's right here. And that's exactly what a performance-based deal does. So how do you share in that performance? Maybe it's the seller not selling all of the equity in the firm, but retaining equity. So they're riding together with the buyer. Maybe it's some of the payments being more the earnout, what we call earnout payments, and earnouts that period during which it's estimated it's going to take for seller to transfer the goodwill and client base over to the new owner, making payments of the part of the purchase price that are those earnout payments heavily contingent upon the actual performance of the firm post consummation.
I think one of the things always, like, if I'm a seller and I think my firm's worth 3 million, you're a buyer, you think it's worth 2. If you're a seller and you're going to be involved in transitioning over referrals and clients and kind of carrying that forward, and you really believe the revenues are just going to stay, right? Like the revenues are going to be there. I'm not worried about it at all. The buyer is. That's why they believe your firm's worth less than what you're asking for. And so that's where this performance piece, this earnout of basically saying, okay, I'm a seller. I'm going to stay on and help transition clients and referrals and these revenues. And I believe in it. So if I do, and we retain this revenue, right, then that percentage will be paid to me. And the buyer says, well, that's great. I think you're going to lose this revenue. So if you retain it, I'm happy to pay you that based on that structure and everything else to do it. So usually those are win-win, right? And to some extent, the sellers always want cash at closing. But I think it's one of these things that knowing you have to transition, right? Like these referral sources and relationships and your personal value, you're betting on yourself, somewhat on the buyer, but you're betting on yourself that those relationships are that strong, everything else to really carry that forward. And it is a sharing of risk, but it's also one that you can manage, right? Because you're in that seat of transition to really go to the clients and know what those relationships are to carry that forward. So yeah, I mean, I think that we've used, of course, seller variable notes, right? Which it's like, great, it's $1 million, but if the revenues don't reach this benchmark, right, it throttles down.
Yeah, absolutely. And I think, it's wise to circle back to our discussion about processes, systems, and procedures here, because what I describe that is, seller's investment in those things is a de-risking of this earnout. It's a de-risking of the deal. You're de-risking the deal for the buyer. Your $30,000 investment in systems, processes, procedures, getting that data available, etc. By doing that, you're de-risking the transfer of the goodwill and client base over to the new owner, because things can be measured and monitored more readily in doing that. And so, but by de-risking the deal with that $30,000 investment, you may be able to realize less of your deal in this performance basis and more of it in actual cash that you get, whether that cash comes at close or whether that cash is part of the guaranteed cash payments as part of your earnout period. Either way, you're facing less risk as a seller in the deal by having less of the deal presented to you as an earnout based deal. So full circle here, back to the process, systems, and procedures, so that we don't have this $2 million buyer offer versus a $3.5 million seller belief in value. Like, you can bridge that gap significantly with these systems, processes, and procedures.
Mike, we've already talked about, valuations being a deal killer, right? I know, as part of our approach and anything else, why do you think, right? Or why do you tell people that knowing the value or getting a valuation, truly a market analysis for their firm, is the first step? Like, why is that such a key part to really determining, kind of those next steps, or otherwise, as, most approach like, hey, let's just go, right? Like, I'm ready to go. Let's go find a buyer, everything else. And of course, it comes with time and cost and other things, as you're kind of saying, with quality of earnings review and all these other things to get ready. But why is that a deal saver, right? If you do it early and everything else.
Yeah, I think first of all, owners a lot of owners don't know their own firms. Like, they know what the client's like, they know how to practice law, but they don't know their firm as a business per se. Beyond that, their bills are paid, they're making a profit, etc. But the real inner workings of the firm are clear, and they cannot clearly articulate what those are. And, in our valuations, as you know, we always present the buyer, the seller who takes these valuations with a scorecard, so they can get to know, like, what is the status of their systems, process, and procedures, like what improvements could be made, etc. So those are the obvious ones. But the second thing is, like, disabusing themselves of those preconceived notions about value. And service industry businesses, X multiple, it's like, no. And here's why, right? So then it's coming down to that page. And maybe the answer is, that's fine. This is what the value is. I can't sell at that value now. I need more money, so I don't sell. And right there, you haven't necessarily killed the deal. You actually saved yourself from being involved. You saved yourself time, money, effort, etc. in the deal process because it's costly. The deal process is costly. It's not just the valuation that's going to be expense. It's going to be your advisors. It's going to be your fiduciary. It's going to be ethics counsel. It's going to be an M&A lawyer. There's a lot of transaction costs that are involved with these deals. And so just being involved in a deal when you know what the result is going to be at the end is something that is a savings to you. But it also, I guess my last point about valuation is it gives you a point from which to negotiate. You're not presenting this valuation to your buyer. Maybe you have a right to, but that's not really, there's no obligation to. It's giving you an understanding of, where am I at? What can I reasonably negotiate? I always say if you have a good strategic buyer, maybe 10 to 20% over that valued amount is what you'd realistically be able to negotiate in a deal. But it's also knowing and getting comfortable with what deal structure you'd likely be offered. So if you're coming into this thinking, I'm going to get 3 times revenue and it's going to be 95% cash at close, no, it's not. It's just not. And it's better off that you know that now than as you go to do it, as you enter into a deal.
I think the biggest thing is those that really go through the exercise, there's always goals, right? Whether those are financial goals, otherwise, something we didn't talk about in Deal Killers is just that it's enough for you personally to walk away, right? To stop working, to exit your ownership of the firm. For most lawyers, I think that reach out at this certain point, like that's not the big concern. Like they have their own retirement funded, but for a lot, they don't, or they know they need to. But the overarching thing is when they come in and they do evaluation, to your point, Mike, is it's comparing what their goals were. Like, this is my goal. I want to get X out of it, right? I want to be out in, 6 months. I want, 95% cash at closing. Like these are all things that are potentially goals in their head. And when the valuation comes out, it's, well, look, you've got some, weaknesses in the firm. It's a very niche practice. So it's going to be a little bit longer timeline. You're probably going to have to transition a little bit more. And all of a sudden it comes down to, well, wait, those don't meet my goals right now. Let me go back and fix them. Right. And, I think the coolest part we have now that, is we have law firms that do valuations every year. They're just like, let me use this as a benchmark for building exit value, improving my firm, going through that. So I am more prepared. Mike, I want to talk about one of the biggest things that I think just in working with you, anything else, I'll call it deal therapy. And really going through the overall aspect of saving deals, right? I mean, we can be known to kill deals if we don't think that they're really a good deal for either party, and that's okay. We want win-win deals. But your role as a deal therapist, meaning, kind of resetting maybe expectations of a seller or buyer. Can you share anything about that of kind of, examples of where that's really come in that you've been able to work with both parties? Because I think that's the biggest thing is that as we go through this of deal killers, a lot of them we're focusing on our law firm owners looking at exit or sale, but a lot of them are the buy side, right? Of just, trying to get educated, trying to approach the wrong thing. And so I do think deal therapy of having somebody come in as that intermediary, mediator, whatever you want to call it, helps. Anything to kind of share or examples you can share on that?
Yeah. I mean, I guess taking a step back and how I get ahead of that, on these deals is the first question I ever ask a seller coming into this process is, I want to talk, they start with numbers and throwing that around. I'm like, in the law firm world, price isn't the most important thing that sellers care about. And that sounds odd saying that, but it's true. In almost all of these deals, the sellers have this sort of preference. One is legacy protection. What are you going to do with my firm? What's a reputation in the community going to be after you acquire it? Is this going to be disastrous? Are people going to view me as selling out to an entity purely for money? That's not going to do a good job for my clients. Are you going to be able to do at least the job that I did for my clients or better? That's what I really care about, because I'm probably going to still live in this community, even though I sold my law firm. I'm not punching out of the matrix and living off grid. Like, I have to live with the people in my community who I've served. So I would say legacy protection is the most important. The second is, how are you going to treat my staff? Are you coming in here and just cleaning house? Are you going to just hack and slash? Is that your approach to extracting profit from my firm? Is that your methodology of improvement, or do you have a vision? Do you have a plan for my firm? Do you have a growth strategy for my firm? And then I would say the third thing that's important for these firms, for these owners, is price. And so knowing that and knowing those preferences, the first thing I ask these owners are, what are your personal, professional, and financial goals? And they're a little bit puzzled by that. But that question helps me understand what the deal parameters are before we even go to market. What can I negotiate? I'm only going to be able to negotiate the price parameter so much in a deal. But there's other things. If I know you prefer that, a certain color on the walls of your building, as an extreme example, like if I extract a promise from the buyer that they're not going to change the colors on your wall, like that's something that you prefer. And like, this is, I think, what I grateful to my professors who trained me in economics, is to understand that preferences extend beyond just price. So learning what those preferences are of the seller helps me have a lot more room to negotiate in an offer. Personal, professional, and financial goals. The other thing I tell sellers is that if you know, in a marriage, when you go to get your marriage certificate, that's an opportunity to legally change your name there. So this is an opportunity. Consummation of a transaction is an opportunity to shuffle the deck on what your duties are, what your responsibilities are. I don't like accounting. I don't like bookkeeping. I don't like hiring and firing staff. Well, guess what? We're going to negotiate a deal where you'll never have to do those things as well. You're going to have more free time to do X, Y, and Z that you like to do. Or maybe you don't want more free time. And we know that a lot of our lawyers are terrified of having free time on their hands, but they really like doing something that their time currently is not freed up to do. And that could be, I want to be in the courtroom more, or I want to be out there marketing and advertising more. Well, a deal is an opportunity to do this. And so these are some concrete things that I could negotiate an offer around. Some of those things may not be as important, conversely, to the buyer. Sure, I can give you more equity in my MSO. If you're willing to, you want $7 million and I'm only willing to give you $6 million. Well, maybe if you're willing to take more in equity and less in cash, we'll move closer on price, etc.
And I think that's, kind of that reoccurring. I think everybody comes in with probably a preconceived notion of, right, of how this transaction should work. They may not always admit it, but buyers are coming in, they're of a different generation. A lot of times, they've maybe bought businesses or otherwise before, and our sellers are coming in. So the ability to say, well, have you thought about this? And then to kind of communicate the why aspect of that. One of the things that, Mike, I think I've kind of learned and taken from you is fit over financials, right? Matters. And it's beyond the financial deal. So you get like, hey, here's your purchase price. Here's how it's going to be paid. Here's compensation for you after you're going to do this. But do you feel good about this buyer being your legacy, right? Do you feel good about this buyer's willing to craft this role for you, to be a marketer and stay active, or to stay as first chair on complex trials, or to be the estate tax guru or whatever else within the firm? Like, does that check your boxes? And I think really, as you get to deal therapy to try to win, where deals seem to be apart, it's really remembering that fit is going to matter more typically than the financials do. Everybody wants to get their financial marks met. I was kind of making some notes. I'm going to go through. Emotions. How would you rank 1 to 10, right? Emotions of a deal killer. 1 to 10.
10.
10.
Being one of the most significant things that kills deals.
Buyers understanding how to approach sellers, whether they're private equity, another law firm, anything else. Buyers understanding how to approach buying a law firm. 1 to 10. Deal killer.
8.
8. Valuation and deal terms.
9.
And then data, systems, the financial accounting, otherwise.
8.
8. So emotions, number 1. And I think that probably surprises a lot of people, because I always joke, did you know lawyers had emotions? I didn't know this, right? That we had emotions, right? we like to bottle them up in our roles. A lot of times we can't show them, right? We got to be that advocate. But it is funny. And I think that's a big thing. That's a reoccurring theme, probably be a reoccurring theme through the podcast of helping lawyers looking at sale, to just deal with that. Overall, there's always deal killers. I think the overall message, Mike, you'd probably agree with is know them, work on them early, right? So if you can work on the emotional readiness, if you can focus on as a buyer, how to approach sellers, what's that right messaging, everything else. If you're a seller, knowing your value, knowing what deal terms to expect, right? Getting your advisors even on board. If you're looking to sell, getting your attorney and your CPA on board then, as you're going to market is a great thing, right? So you can kind of discuss and make sure of that. And then financial and data and systems, right? Get those in order. And if you go through an exercise and they're not in order, go get your house in order before you get into this. And you need some of these deal saving techniques, or you need deal therapy, or any of the extremes to do so. Mike, this has been great. I greatly appreciate your time. I'm sure you'll be back on and there's lots more to share. You'll get off this call and probably talk to 4 other deals and have 4 other stories to share from that. But I appreciate you joining us. We're excited to launch this. If you're sitting as a law firm owner right now, Mike Di Gennaro, law firm owner, right? Esquire, you've got it on the door, everything else. And you were really thinking about, what your firm looks like in the next 5 to 10 years. What is one thing that you would truly focus on or do as a law firm owner seat? You're sitting there, right? No other details. What is one thing you would do as Mike Di Gennaro, owner and founder of the firm?
One thing I would do right now is do anything I could to find out where I'm at. Because you can't go anywhere unless you know where you're going from. And so that would be having a evaluation of the firm done. I want to know what its performance is, what the pain points are, what deal structure I would be looking at. And then, even if I'm not ready to sell now, that knowledge, I would know what to do to improve my firm and get it ready to sell in some time in the future.
Great advice. Know where you are so you can decide where you're going. Right. Absolutely. Mike, thanks so much for joining us and being part of the podcast and, of course, being part of the LPE team. Greatly appreciate it.
Thank you, Tom. Great being here. Have a good one.